I'm very pleased to see all of you. Um, Thank you very much for being here. We have what we think is probably going to be an event that we are going to run um, on a few occasions because it's all about people understanding their rights. And we think that a lot more people should know much more about their rights. So if this event works, in other words, if you folks find it useful and helpful, and if you think we ought to run it again in the future, we'll run a variation of it in due course. And before I do anything else, can I please thank very publicly Mr. Ian Duffield? It's really Ian Duffield who is the inspiration behind this event. Many of you will know Ian. Ian contributes very fully to the Transparency Task Force programme of activity. He's a member of the Secretariat Committee to the All Party Parliamentary Group. He participates in lots of our meetings and he always contributes really fully. And it became very obvious very quickly that Ian Duffield knows a lot about things like statutory rights because of his career background. And I'm sure that when Ian's presenting this evening, he'll take time to tell you a little bit about his background. We're also going to be hearing from Lou Baxter-Scott, who we also rate incredibly highly. Lou is a very passionate protector of consumer rights. She has a very senior role at Trading Standards, particularly on the fraud side of things. Lou's also on the Secretariat of the APPG and is a member of the advisory group for TTF. And we really could not think any higher of Lou Baxter-Scott than we actually do. So it's wonderful that we've got Lou and Ian talking tonight. Ian's going to be doing most of the work. And then we'll go to Lou and then a few others will be chipping in. We are planning to wrap up at about 2 o'clock. So we've got about 56, 57 minutes left. Just for good housekeeping, I will mention that the session is being recorded. We will be publishing the recording in a few days' time. We're also are going to circulate notes that get put into the chat to all of the attendees as well. And I'm going to be sharing Ian's slides, which I'm just getting to in a moment. Let me get to those shortly. We're going to pass over to Mr. Ian Duffield, who's going to introduce himself and I'll be turning the slides as we go, Ian. Okay, so let me get myself organised a little bit better than I am now. Forgive me, folks, it's been a bit of a day and a half. Mr. Ian Duffield, please take the mic, sir, and take it away. Thank you very much indeed, Ian, for all the preparation you put into this and for delivering about what you're about to deliver. Thank you.
Yeah, you're welcome, Andy. And can I just say thank you to yourself and to Alexander for all the effort that's been put in the background with the slide deck. And thank you also to Louise Batzer for joining us this evening. I'm sure there's plenty of stuff that she's going to be able to add to. Just to give people a little bit of background about myself, because Andy's asked me to do that. Before I retired, I worked for one of the largest retailers in Europe. I actually worked for their business to business division. And there I was head of legal and finance operations for a while. And towards the end of my career, moved on to contracts and compliance. And one of the things that I did was actually help set up an offshore shared service centre and helped train them. I was also head of training and education for them. And one of the things that I did do was train them in consumer rights and contract law in general, because they were going to be the people who were actually facing the customers when issues arose. And it was important that they understood the clients and the customers' legal rights, because that is massively, massively important to any reputable business. So that's my background. Without further ado, there is a slide deck. It's more of a framework, and it's so you don't have to look at as much of my ugly mug as possible. The presentation I'm going to give will take probably around 20 minutes. It's in a Word format document, which, as I understand, you will be able to download at the end, so you needn't concern yourself with the detail. We will be getting into a lot of detail, but this is about your statutory rights. It's not about the enforcement of those rights. There's a whole separate drafts of legislation in relation to those, and that would take much longer to go into. I will touch on them a little bit as we go, and I'll give you a couple of little anecdotes and stories. So a little bit of ad-libbing will go on. And what I will do is at the end of each section, I will ask Louise to add anything that she wants to, anything she wants to comment on, and to take part in that section by section. And then at the end, I will hand over to Louise to talk about anything that she wants to talk about. And all being well, there'll be a little bit of time afterwards for a Q&A session. So without further ado, this is your statutory rights in the UK. Can we have slide 2, please, Andy? Thank you. So the first thing is, can your rights be excluded? And the answer is very simple. No, they cannot. No attempt can be made to exclude your statutory consumer rights, and any attempt to do so is automatically invalid. And indeed, it may also be unlawful. Criminal prosecution be taken against traders who attempt to do that. And that's the sort of thing that, for example, trading standards would do, or it may be the regulators if they are involved. Private sales are exempted because this only applies to you as a consumer, and that means you are dealing with a trader or a retailer in some form, a business. It could be an individual, but it would be as a business transaction, not as a private sale. Okay, now there are certain implied terms in any contract for sale of goods or services, and they are that the goods or services must be of satisfactory quality, they must be fit for purpose, and they must fit the description that's been given. Goods, services, and digital content must meet all of those and be suitable for their intended purpose. Okay, now services must be performed with reasonable care and skill, and that will be the sort of standard that a reasonable person would accept based on the nature of the trade or the trade of the person that's delivering the services. Liability for death or personal injury caused by the negligence of either the supplier or the person delivering the services cannot be excluded or limited for death or personal injury resulting from negligence under any circumstances. It does not mean that something bad might not happen, because that happens. So just if you get hit by lightning walking across a shop's car park doesn't mean you have an automatic right of any compensation for them, because the key ingredient is it has to be negligence by the trader involved. You have a right to a remedy, and terms that make it difficult or onerous for a consumer to exercise your rights. And a good example of that is a sign that says no refunds. Okay, a no refunds policy or making any enforcement subject to restrictive conditions are automatically void. They're automatically void also under the Unfair Contract Terms Act, and they may also be unlawful. Depends on the nature of the attempt to exclude them. And as we've said, private sales do not apply. This only applies to retail or a retailer or a trader. So slide 3, please, Andy, if you will. Now, the key legislation here is, first and foremost, we're going to be talking about the Consumer Rights Act. The Sale of Goods Act 1979, Supply of Goods and Services Act 1982 are the historical legislation. They are still in force for a reason which I'll say to go into at the moment. But the main legislation now is the Consumer Rights Act 2015, which has updated the other two. We're also going to be looking at the Consumer Credit Act 1974 later on. And as I've said, the Unfair Contract Terms 1977 generally applies to any contracts, whether they be made with a consumer or a business. And towards the end, when we get into enforcement, we'll also be looking at the Limitation Act 1980. And slide 4, please, Andy. So, as I've said already, there are implied terms with any sale of goods and services, and that they must be fit for purpose. They must be of satisfactory quality, and they must be as described. Okay. Now, fit for purpose means it's the normal purpose that such an item would be used for. Or it could be any specific purpose that the supplier stated, or one that you specified and the supplier agreed to. So if you go along and you buy a pair of Wellingtons, they must not let water in. Okay. If you want to buy a pair of slippers, that's fine, as long as you understand that they'll be letting they will be letting water in. And if a trader says, yes, these will be suitable for wading about in a muddy swamp, and it's a pair of slippers, then there's a breach of your consumer rights because they have made a representation that is not true. They must be of satisfactory quality. Okay, they must not be damaged or faulty. Satisfactory quality is based on, again, what a reasonable person would expect. It does cover the price paid for the goods. If you pay more money, you are allowed to have an expectation that's greater than if you paid a lower price. And whether the goods are marketed as a quality item and durability. Just touching on a little comment about that, about a quality item. There was a case many years ago where Mercedes-Benz sold a car. It developed a fault in the chassis. Now, at the time, Mercedes-Benz had a manufacturer's warranty, which we'll touch on a little bit later, which was for 3 years. And they attempted to rely upon that, or at least the trader did. And the court found against the trader and for the claimant, because a Mercedes, at the time, the marketing material was advertising the Mercedes as a quality car, better than a standard car. And therefore, the court decided then in which case a customer would be entitled to rely on a better level of construction, and 3 years for a crack to appear in the chassis of a quality car was unacceptable. Okay. The Act also covers second-hand goods as well as new, but if you're buying second-hand goods, there must be a reasonable allowance made for their condition and the fact that they are not new. That's exactly the situation that would happen, for example, if you were buying a used car apart from a new one. And as we've said, they must be as described, and that includes any samples that you've been shown, anything that may have been said to you by the salesperson. Okay, if they make a statement, then that becomes part of the contract. And services must be carried out with reasonable skill and care. If we can have a slide 5, please, Andy. Okay, so these are the timescales for claims. We'll look at within 30 days, we'll look at 30 days to 6 months, and we'll look at after 6 months. Okay, now again, this is in respect to the timescales that are set down for the Consumer Rights Act 2015. So the timescale for a claim, the clock starts ticking when you take possession of the goods. And please take note of that little phrase, when you take possession of the goods, because it also relates to other things. If they are being delivered, they must be delivered within 30 days, unless agreed otherwise. After that, you can cancel if you wish and get a full refund of your money. Now, within 30 days of receipt of the goods or services, you can reject the goods and get a repair, a replacement, or a full refund, except for perishable goods where life expectancy time limit must be reasonable. Now, remember, this is only if the goods do not meet those implied terms of being of satisfactory quality as described and fit for purpose, not because you've changed your mind or because you don't like the colour when you knew what the colour was. Okay, it's only for faulty goods or services. And this is known as the short-term returns time scale. Okay, so that's within 30 days of the receipt of the goods. Now, if the cost of a repair or replacement is disproportionate to the value of the goods, for example, it may be relatively low value goods, but the cost of shipping you a replacement may be extreme, or the cost of actually sending an engineer to repair them if that's necessary may be disproportionate to the value of the goods, the retailer can refuse that specific remedy, but they then must still provide one of the other remedies. Okay, And a refund does not automatically apply to downloaded digital content, such as videos, music, any apps. But if they are faulty, then again, you are entitled to a repair or replacement or a partial refund, which may turn out to be full. But the reason for that, of course, is because with downloaded digital content, it's possible to buy a CD, watch the video, listen to the music, and then return it. So it takes into account the fact that it may still have been possible for you to use it. Okay. Just one little word on returns. A trader must also cover the cost of the return. And again, that return would be from the point at which you took possession of the goods. So if they were delivered to you, then the supplier must either collect them or in some circumstances, it might be appropriate to send you a prepaid label. Okay. If and however you pick the goods up from the trader's premises, then you must return them to the trader's premises. So returns apply from where you took possession of the goods, but the trader must cover the cost of the return if the goods are faulty or have broken one of those implied terms. Over 30 days and up to 6 months, it's assumed that the goods were faulty at the time of supply, and the burden of proof is on the trader to prove otherwise. That's crucial because what we're talking about here is, in essence, a breach of contract. If goods are supplied that do not meet those implied terms, then there is a breach of contract. That's different to where goods become faulty over a period of time. You must give the retailer one chance, and that's one chance only, at a suitable repair or replacement. If that repair or replacement fails or is unsuitable, then you can claim a full refund or a price reduction if you wish to keep the item. You can state your preference, but the retailer can provide an alternative remedy. As we've said before, if a remedy or replacement would not be possible or disproportionate to the value of the goods or one of the other remedies. But the trader has to take into account if it would cause you significant inconvenience or delay. For example, they offer you a replacement, but it's going to take 6 months to get it to you, in which case they should refund your money. Now, crucially, I'll make a separate comment here in respect of vehicles. In the case of a car, the trader is entitled to make a reasonable deduction for the use of the vehicle, and typically that might be mileage used. So a little anecdote for you here. A while ago, my son bought a car, a second-hand car from an auto trader. The car had some problems with the gearbox. He returned it to the trader, who made an attempt at repairing the gearbox, said that they had done so. The car came back to my son. He still had problems with it. And by this time now, he had passed outside of the 30-day short-term rejection period. He was into the between 30 days and 6 months. Contacted the trader and said that he was going to return the vehicle or want a replacement because one attempt had already been made at repairing it. Now, the trader made a very bad mistake in telling my son that he was not entitled to return the vehicle after 30 days. So I drafted a letter for my son to send, which pointed out a number of things, one of which was that it is unlawful to attempt to mislead a consumer in respect to their consumer rights. So that was the first mistake he made, and that is a criminal offence. Okay. The second problem he had was that there's a little act. It's not a little act, it's quite a big one actually. It's known as the Road Traffic Act 1988. And in that, it states that no person, and that includes a private person, so I'm giving you this backdoor information here in case it ever becomes useful to you, it is unlawful to sell or to offer for sale an unroadworthy vehicle. So anything that would cause a car to fail an MOT or be obviously and clearly unroadworthy, not a simple error like there's a cut in the upholstery or whatever, means that the trader becomes liable once again for a criminal prosecution. And as I said, that also applies to private sellers. There's also another little known act, which is called the general um, product and safety regulations 2005. And that does the same thing, except applies to all manufacturers, distributors, and traders for all goods, which says they have an obligation to make certain that anything they sell or distribute is safe for use. The morning after that letter was sent to the motor trader, he promptly decided that he didn't think it was necessary for this to be escalated any further, and promptly offered my son another vehicle as a replacement. So just a little bit of extra information there when it comes to actually getting your consumer rights dealt with appropriately, is it can be very useful to push the item over and threaten to report any trader acting unreasonably to the trading standards, because I also put in the letter that rights were reserved to refer the matter to trading standards, because it's trading standards who would bring the prosecution against a trader acting in that way. You can, of course, bring it yourself by applying to the courts, where they would then rule on the legislation, because they are criminal prosecutions in addition to any compensation you might be entitled to. Now, after 6 months, you must give the retailer one chance at a suitable repair replacement, as we've already said. And if that fails, then you're entitled to a refund, but it may be partial based on what is fair and reasonable use you have had of the goods. We've already said specifically this is the case in respect of cars, where it usually is based on mileage used. However, the burden of proof that the goods were faulty or the damage was there before you took possession, in other words, at the point the contract was formed, that now sits with you. And then after 6 months, this can continue for a period of up to 6 years. It doesn't terminate just after 6 months, because 6 years is when the Limitation Act prevents you taking legal action to enforce such rights. We'll touch on that briefly later on. Now, this act also applies to foreign suppliers in another country. So if you're on a website in China or whatever, or any other country, you still have your statutory rights under the act if the foreign supplier specifically markets in the UK. And examples of specific marketing could be where a website is written in English, where the price is quoted in GBP, Great British Pounds, or where there is specific mention of deliveries or supply to the UK. That means they are actively marketing in the UK. Now, enforcing those rights may be difficult, but this is where our good old friend, the credit card, could come into use, because if you buy them using a credit card, then other rights will apply, and we'll get onto that shortly. Okay. Now, the Consumer Rights Act does not prevent you exercising any other legal remedies you may have, such as claiming damages, repudiation of the contract, which means treating the contract as ended because the breach by the trader is so fundamental to the nature of the contract. Specific performance, which means making the trader honour their obligations under the contract, maybe something particularly that you've bought that the trader then does not want to supply for some reason. And under the Limitation Act, as I've just said, Limitation Act 1980, you have up to 6 years in which you can bring a legal claim. Now, they're your rights under the current consumer legislation. Louise, can I invite you at this point, please, to add anything at all that you want to add to comment on, or add in at this point?
So,
I think you've got pretty much all nailed down, to be honest. You're covering all of it.
Thank you.
You are.
But please, any comments you want to make, any corrections if I screwed up somewhere along the line?
No, not at all.
Anything.
Not at all. The only thing that I was just going to say is that if you do look for a rejection, so you do look to get a refund within the first 30 days, you don't get the same reverse burden of proof. So you have to prove the item's faulty rather than them proving that the item was sold without a fault. That's
Correct,
the only
yes.
slight tweak. And that is I love consumer law, but equally despise it because that's hidden within the legislation, which makes it more complicated for consumers to understand. From my perspective, I run an organisation called Consumer Friend, which is consumerfriend.org.uk. There are easy guides around your rights on this website, and there are template letters if people ever need them.
That's great. Thank you very much for that. Yeah, just to touch on that point, as Lou said, it's the implied term that goods within 30 days are that any fault, in fact, goods within 6 months are automatically assumed to be faulty, and the burden of proof sits with the supplier. Okay, but as I said, certainly once you get outside the 6-month period, or with any purchase of goods generally, the burden of proof then passes to you as the purchaser.
It's just that slight tweak, isn't it? Because if you're looking for, so even within the first 30 days, if something
Yeah.
goes wrong, you can opt for a repair or replacement, and essentially your 30 days gets the clock gets stopped within those 30 days.
Correct.
So that you've got that 30-day period. But within those, if you are opting for a refund, if the company that you bought from is pedantic, you will have to prove that it's faulty.
Sorry,
rather
yes,
than
absolutely right. So if you were to return goods for, let's say, a repair, the clock stops while the repair is carried out. That might take 2 or 3 weeks. It passes over the 30-day period, but that 30-day timescale is suspended until the supplier's completed the repair. But as Lewis rightly said, and you're right, it is not made very clear in the legislation.
It's not made very clear that if you opt for a repair, you don't have to prove it's faulty. But if you opt for a refund, you have to prove it's faulty. The laws it's irritating and really complicated. But as I say, there's some simple guides, and also we can help. So
yeah, no, great. Thank you for that clarification, Lou. That's absolutely correct. Thank you very much. If we can have the next slide, please, Andy, which is slide 6. Okay, so we're going to move on to here, the Consumer Credit Act 1974, and this is to do with Section 75 credit card claims. Some of you may be aware of this, so I'll go through the details of this. And that is the fact that if you apply Section 75, you can make what's known as a joint and several claim against both the credit card provider and the trader. Now, it just doesn't apply to credit cards. It actually applies to not any, but a number of finance agreements, including a credit card, where you can make this joint and several claim. This includes point of sale finance agreements, but not necessarily buy now, pay later agreements. You can also claim if the supplier goes into liquidation. So, for example, you paid your credit card, supplier goes into liquidation, you don't get your money back off the administrator or all of your money back, you can then make a claim against the credit card provider under Section 75. It does not cover payments by debit cards or charge cards because they're not finance agreements. It only covers finance agreements and credit card payments. Now, the applicability of this is that the price of the goods or the services must be more than £100. Okay, so that's £100 and a penny or greater, but not more than £30,000. If the price is the price of the goods or the services that matter, not how much you pay on your credit card or not how much you're paying under the finance agreement. And it includes partial payments and deposits. So in other words, give you an example. If you paid a £10 deposit for a new carpet costing, let's say, £200 on your credit card, you're covered. If the carpet is then not supplied, say, for example, the supplier goes into liquidation, then you can claim your £10 deposit back. And it's only £10 because you can only claim for your actual loss. And at the moment, that's all you've lost. You can claim that back off the credit card company. However, if you paid the balance of the remaining £190 in cash to the carpet provider, you're covered for the full amount of £200 because it doesn't matter how much you paid. It could have been 1 penny. It only matters that an agreement was incorporated using your credit card provider. So if the carpet is then not supplied or fails any of the satisfactory quality, fitness or other implied terms that we've already spoken about, you can get the full amount of your loss back, even though you may only have paid £10 on the credit card. Okay, you could claim the full £200 back. The payment must be for a single item, and each item that you're claiming for, if it's under £100, then you are not covered. So if you buy 10 items costing £20 each, hard lines, you cannot recover the money for all of them, or indeed any of them, because none of them are over £100. Okay, so it's a single item value. Excuse me. The lender, now this is if you're using a finance company agreement, not paying by credit card necessarily, but the lender, if you're using a finance company agreement, must not also be the trader. In some cases they are. Okay, in some cases the trader will be using some finance arrangement that they are doing themselves. You must also be paying the trader direct. And again, this now also includes credit cards. You must pay the trader direct, not using a third party. So that means you mustn't use PayPal or another payment service. Also, if you're paying an agent, for example, a ticket agent, because typically tickets and bookings for venues of that are made by agents, then you are not covered under the Section 75 claims, or you may not be covered. Best way of thinking of this is a triangle. There has to be three parties. There has to be the finance provider, credit card company, or finance company agreement. There must be the trader, the person supplying the goods or services, and there must be the consumer. In this case, it would be yourself. If you use a payment platform, a payment provider, then there's now four parties involved. So then the Section 75 option does not exist. You may also have a problem if you're making a claim, if you use your credit card to pay for something where the beneficiary of the supply is not you. This would be a matter for the credit card or finance provider to decide on. So, for example, if you're paying for a holiday for a family member, then it can be a problem of where the point of contract actually exists. So if you're the beneficiary, no problem. If you are not the beneficiary, you could have a problem. Time scale. Under the Limitations Act, you have 6 years in which to bring a Section 75 claim. That's the Limitations Act, where you can take legal action against a party that is in breach of a contract. There's no specific time for the claim to be resolved, but if you are unhappy with the length of time being taken by the financer, by the credit card company or the finance agreement company, you can make a complaint, and then your complaint must be dealt with within 8 weeks. That complaint would go to typically the Financial Ombudsman Service or any other regulator that may be involved, but typically, because it's a finance agreement, that would be the Financial Ombudsman Service normally. If it's not dealt within 8 weeks, or if your claim is refused, or if you were deadlocked, that is, if you reach a point where you are asking for more money or the money and the provider is just refusing to agree and to accept your claim, then you can, with the permission of the provider, not have to wait for the 8 weeks. You can apply immediately to the Financial Ombudsman Service. Okay, so it's 8 weeks maximum in which they must deal with your complaint. If they refuse, or if you reach deadlock where you just can't agree what is going to be happening, then you can ask for their agreement to let you go straight to the Financial Ombudsman Service. Louise, can I invite you again if there's anything you want to add or comment on that?
No, just that Section 75 has been reviewed by the Treasury, hasn't it? Recently, there was a consultation in relation to Section 75.
Yeah.
And we're in a little bit of jeopardy that potentially it could go, but it's not, which is ideal because it would fundamentally undermine the consumer protection landscape. So it's a very useful tool. Just from a bank card perspective, whilst you can't use Section 75 if you use a debit card, some banks will offer a chargeback system if the item isn't received. So you can use chargeback, and also don't forget the authorised push payment refund system that you can access via your financial institution.
Louise, thank you very much. Slide 7, please, Andy. And there we go, chargebacks. This is what Louise has just mentioned. This is a voluntary service from card providers. So typically this will be your banks if you're using a bank card. It applies to credit card, debit cards, and charge cards. Now, it's a voluntary service provided by those parties because they want you to use their cards. Generally, the request must be made within 120 days. Now, that can vary because I said it is a voluntary service, so it would be best to check with your bank or other provider. And it can vary slightly. So different providers do have different terms. So check with them for more details. Now, there's no value restriction on a chargeback. So the £100 minimum spend, or sorry, £100 and a penny minimum spend, or the £30,000 upper limit does not apply. So you can use the chargeback system for any amount of money. Okay, so that's chargeback. So these are other options now you can take. Litigation is one of the other options that we've mentioned. And again, under the Limitations Act, generally have 6 years in which you can bring a legal action against any party. I say generally because there are exceptions, but they're quite extreme and wouldn't normally apply to consumers because you're getting into contracts for the sale of land and various other things. So for most purposes, it's 6 years. The time starts when you become aware or reasonably should have known of the problem. Okay, so when you become aware or reasonably should have been aware that there was a problem. It doesn't necessarily mean it's when the actual date of the transaction was. If there's been a deliberate fraud or a deliberate concealment, sorry, fraud is by definition deliberate, or a deliberate concealment by the trader, then the clock starts when you become aware of the fraud or concealment. And of course, in certainly the case of Louise has mentioned push payment frauds, they can actually take some time before you may become aware that there's been a fraud. But I don't want to get into that in any detail because there's separate, very complicated situations around sort of push payment frauds. And as Louisa said, at the moment they are being looked at and they may change. But we're talking about what the situation is now. Now, if you want to undertake litigation, you can make a court claim and you can handle the claim yourself for up to £10,000 and argue the case yourself. That's actually not too difficult to do because it's done in a very informal way. If you're getting over £10,000 and up to £25,000, it uses a slightly different track, and you may at that point want to consider using the lawyer because the procedure in the court gets a little bit more formal and is not quite as simple. But certainly under £10,000, the process is designed by the courts to allow people to argue the case themselves. Generally, costs are not awarded, generally, and if they are, they're generally only awarded at a nominal level. So that might include a party's transport cost to get to court or whatever. But the whole idea of it is to make litigation cheap and relatively easy for individuals to take part in without having to risk huge sums of money on legal action by employing lawyers. And it also means that the other side cannot claim the costs either. If they choose to bring a lawyer to the fight, that's up to them, but then they would not necessarily get their cost back. And there is a link that I've put in the actual presentation, which you can download as the Word document, where to go for that. And then finally, you've got trading standards. There are other regulators, but trading standards in particular, if a trader fails to adhere to the requirements of the Consumer Rights Act, or tries to exclude those rights, or tries to mislead you by telling you not covered by them, they could face a criminal prosecution. Threatening to report them to the local trading standards department, as the example I gave earlier, may be enough to make them honour your rights. And it's the trading standards that can bring those criminal prosecutions against traders who break the law. And I think that's something where Louise could be particularly useful on her website. Just one final comment. Unsolicited goods. Unsolicited goods do not create a contract. So any goods that you have not asked for those of you old enough to remember Reader's Digest, who made an absolute business about this. And as a little humorous point, I once gave a presentation on this to a group of CEOs, and I gave an example of Reader's Digest being a company that made a very good business out of this before the process was outlawed. And guess who was sat in the audience? The CEO of Reader's Digest. He was very magnanimous, and when I actually realised he was sat there, because he was sat right in front of me, and as I looked at him, I realised who he was. He gave me a little smile, but that's just a little interesting anecdote. Well, at least I find it interesting. But there's no obligation, because there is no contract, for you to send them back or even keep them safe. Indeed, you can treat them as an unconditional gift, and you can keep them. and it's a criminal offence for a trader or supplier to demand payment or to pursue in any way any payment or return of the goods or any threats to have you blacklisted or any other nefarious actions that they may wish to take. Okay, so that's the end of the presentation. And again, I would like to invite Louise to talk about anything that she would like to add to this. And thank you for your attention.
The only thing I'd come in on is the unsolicited goods issue. Is we still see that in relation to fraud and scams quite predominantly. People being
Sure.
sent items and then told that they have to pay for them, but it's a way to get their personal information so that they can then be exploited further for
Yeah,
different
absolutely.
sorts of
Yeah.
scams and fraud as well. So always be on high alert if you receive an unsolicited gift would be what I would suggest in
Thank you,
relation
Louise.
to
Yeah.
that.
Okay.
Absolutely superb. Can we show appreciation, folks, to both Lou and, of course, to Ian as well? That was really, really good. Really, really good indeed. And that slide deck gets the message across so clearly. It's wonderful, Ian. Hopefully, you'll be happy to do this again and again and again.
Yes, I would. The slide deck was great. Thanks go to yourself and Alexander for that. The script document, apart from the little anecdotes I've thrown in by way of ad lib, I think is going to be available for download. And again, thank you very much to Louise for her contributions. And at that point, either myself or I'm sure Louise will take any questions
Yeah.
that you may have. We've got a little bit of time left, I think.
Yeah, we have. We have. We're going to hear first of all from Edward Romaine, who's a CEO of Blind Justice UK, and then we're
Sure.
going to hear from Nigel Brams, who's a partner at the law firm Collier Bristow LLP. They've kindly agreed to chip in with some comments if they'd like to. Edward, to you first of all, and may I also sort of formally put on record our great thanks to you, Edward, for your help in relation to Robert's case. It may well have been the bit that made all the difference. So well done to you, Edward. Edward, please do take the mic and share with us anything you'd like to. Thank you.
Thank you very much for that as well. And I'm delighted to hear that I was very delighted to see that email as well. So and Andy, well done to you as well. Fantastic presentation. Thank you very much for that. As Andy said, I'm Edward Romaine. I run Blind Justice UK. I want to begin with something I rarely admit. I'm legally trained. I trained for the bar. I thought I understood the justice system. And then a few years ago, I had to use it myself alone without a lawyer. And I discovered I understood almost nothing. I saw how easily that system defeats people who have done nothing wrong. Tonight's question is about understanding your statutory rights. Here's what I learned the hard way. In this country, your rights are not the problem. We have good rights. We have strong laws, as we've just gone through in the last 45 minutes. The problem is what happens when you try to use them. Because a right you cannot enforce is not really a right. It's a promise on a piece of paper. And for millions of people, that's all it is. A promise nobody keeps. At Blind Justice, we audited how the courts handle people's cases, not the law, the administration, the basic machinery that's meant to carry your rights to a judge. We found that 92% of court documents were missing from files we reviewed. We found that 85% of mandatory submissions never even reached the decision maker. Let that sit for a moment. 85%. People did everything right. They filed their evidence, they followed the rules, and the system simply lost it. That's not bad luck. That's a system that fails people quietly, on paper, before anyone ever rules on the merits. Our evidence on this has been published by the Justice Select Committee. Now, I didn't start a charity to describe a problem. I started it to close a gap. Because the people this system fails are not weak, they are not foolish, they are ordinary people standing alone in a process that was never built for them, holding rights that no one will help them enforce. What they lack is not courage, it's a guide. So at Blind Justice, we're building one. We've built a free tool called the Litigant in Person Navigator, which walks people through their own case step by step in plain English, and something more ambitious behind it, an AI system that helps prepare their cases properly so that the person standing alone is no longer standing unarmed. Transparency, fairness, the rule of law, these are not abstractions. They're tested in the smallest courtroom on the worst day of an ordinary person's life, when they walk in alone and hope the system will keep its promise. Our job in rooms like this one is to make sure it does, to turn rights on paper into justice in practice, because a right that only the well-advised can use is not a right at all. It's a privilege, and access to justice should never be a privilege. Thanks.
Wonderful. Absolutely wonderful. And I'm just putting a note in the chat here. I'm going to read it out actually. The theme that Edward has just spoken about, i.e., rights that are not enforceable in practice, are not really rights. So that should be right, singular right, is a theme covered in this recent piece of work by the APPG. That's the All-Party Parliamentary Group on Investment, Fraud and Fair Financial Services. The APPG has got its teeth stuck into the Financial Services and Markets Bill. Why? Because the legislation is supposed to be about streamlining the system, making it better and fairer and quicker and less bureaucratic and less costly and less burdensome. In reality, we think that whilst there is some of that good stuff, we also think that there are real jeopardies, exactly as Lou was indicating earlier, in relation to things like the Consumer Credit Act and the workings of the Financial Ombudsman Service, etc. So I'll put a link to the document I'm referring to in the chat. It's there for you if you'd like to go to it. Thank you very much indeed.
Andy, sorry,
I was just going to say,
Let's go.
Sorry.
Let's go Lou first. No, go for it, Lou. Thank you. Then we jump
Edward, I was going to respond to you just on one of your points. So on my consumer friend website, we're currently working with regulators around how we ensure consumers understand their rights and have it in easy read. So plain English is accessible, and provide them with the tools to be able to action their claims. Trading standards, and I know everybody's in this position, have no funding. Our funding has been slashed by 60% over the last 5 to 10 years. So there isn't that civil education and enforcement work that we used to do to help people put their claims forward. So we're doing quite a lot of work on that, but we're also doing a lot of work in relation to alternative dispute resolution and ensuring that consumers get access via ombudsman services or alternative dispute resolution. I'm working with the Department of Business around this single front door from a consumer ombudsman perspective. It won't be a single ombudsman, it will be one front door, lots of ombudsmen sitting behind it is the take that I've got. But ensuring that we provide that consistent service from ADR and, I'm using jargon, alternative dispute resolution and ombudsman services, so that consumers can have an expected level, so that somebody will be there to provide them with that support to get redress. Because we're seeing out of the £72 billion that's lost a year from consumers not being able to access redress, only 40, I think it's the stat was 39% didn't even bother, because people are finding the system so hard to access.
Wow. This is important stuff we're covering ground here today. We really are covering important stuff. Lou, thank you so much for your input there. Clearly, Edward wanted to chip in with something as well.
Yeah, it was just, I wanted to come back. It's just one thing that wasn't covered tonight. I just wanted to make a mention of it, is because people don't realize that their statutory consumer rights changed significantly last year under the Digital Markets Competition and Consumers Act 2024. So that just briefly does two things. It bans some practices outright. So hidden fees sprung on you at the checkout, what's called drip pricing, fake and paid for online reviews, subscription traps that are easy to join and hard to leave. And just as importantly, it finally gives the Competition and Markets Authority teeth. So for the first time, the CMA can decide for itself that a business has broken consumer law and fine it directly without having to go to court. And that's up to 10% of a company's global turnover. And that's the part that matters, because, as we keep saying, a right is only as good as its enforcement. And what's striking about this particular act is that it pairs rights with the power to actually enforce them. And that's usually the missing piece.
Yeah, Edward, can I just say, yeah, I'm aware of that act. I didn't touch on it because the list, I think, runs to about 30 odd specific prohibited practices, and would have been here till about midnight. And in particular, it's dealing, I think, more on the enforcement side around, these are things that traders should not be doing, rather than, shall we say, rights that the consumer has. And therefore, I think it's aimed more at stopping bad actors as in trade and supply,
you're quite right.
rather than consumers.
I think if consumers are aware of it,
Agreed.
it allows them to challenge when they see these practices being done, and frankly, it catches them off guard as well. So I think it's always good to be armed just with that.
Sure, sure. I agree.
Again, this is excellent stuff, folks. It really is. The reason I'm sharing my screen is that an article was published today, put together by John McDonnell MP. I'm going to read out a couple of bits from it. Why Andy Burnham MP is right to emphasise the need for good growth, and why MPs must prepare to help fix the new Financial Services and Markets Bill. Those of you who listened to Andy Burnham's speech that he delivered yesterday may remember he referred to good growth as opposed to just growth. And at the bottom of this article, which I'm going to go straight to now, John McDonnell makes, I think, what's a very, very important point. And this is all in the context of the Financial Services and Markets Bill, where various consumer protections are in jeopardy, exactly as Lou said. I'm just going to read out this last bit here before we go to Nigel at Collier Bristow. I was struck by Andy Burnham MP's reference to not just growth, but good growth in every postcode in his important Monday, 29 June speech. I don't know precisely why he referenced good growth as opposed to just growth, but if it is because he is thinking that what our country needs is growth that is sustainable, healthy, and is not achieved through taking away consumer protections, which is irrefutably what the bill as drafted does, and I would absolutely support that notion. There's no way any objectively minded person can look at the Financial Services and Markets Bill that's currently in the Lords and not conclude there are serious consumer protections in jeopardy. I'll carry on reading. Then I'm sure he will find many parliamentarians, including myself, highly supportive of that subtle but important distinction. And we can only hope that whichever individuals get appointed as our next Chancellor and City Minister get the significance of that subtle but important distinction too. I'll close by inviting MPs to get engaged with the bill and to participate in the APPG's work. And he ends with, we are seeking cross-party unity in protecting the interests of all of our constituents, not just for the public good, but also to bolster the economic success of our country through delivering a trustworthy and effectively regulated financial sector, one we can all be proud of. The article is basically a write-up of the APPG summit that we had back in whenever it was a few weeks ago. I'll put a link to the article in the chat. Let's now go to Nigel at Collier Bristow. Nigel, thank you.
Hello there. I'm joined here by my colleague Victoria Kiriakou as well, who's helped me do a little bit of reading on the consumer rights. So by way of background, I'm actually a financial services lawyer. I advise companies and people. So I advise companies which are trying to do financial services business, often smaller companies, because I'm not a big law firm. And we're always advising them how to stay on the right side of the FCA and on the right side of regulation. The other thing we also do is we advise individuals often who have issues arising from financial services, particularly in relation to crypto, which has been a big one recently. And interesting, the reference to the Financial Services Markets Bill, because all the rules and regulations around crypto are going to be changing next year, from October next year, when mainstream crypto will fall within the mainstream of financial services regulation. And that will produce a great deal more protection for consumers than there is at the moment. There is already some protection, and the laws have grown over the last few years. But that's going to change quite a lot. And the big debate actually is around growth, good growth, whether good regulation stimulates growth, and generally take the view that it does. I mean, a free for all is not necessarily good for growth. You actually want to have clear regulation, you want to have clear rules and fair rules which protect both individuals and also support companies who are trying to do business, because without the companies trying to do business, there is no business and there is no growth, and there is money to pay for the schools and hospitals, etc. we want. So I'm thinking of a couple of things I've done recently. We've been advising individuals who've been on the wrong side, been poorly treated by some large exchanges, and we've achieved some quite good results for some of them. Help people get money back that's been frozen for no particularly good reason. We've been to the Financial Services Ombudsman several times now. And yes, it is remarkable how poorly some people are treated by big financial services firms, and also how, but the other side of that is I work for financial services firms who want to do the right thing and want to act ethically and want to grow their businesses in the right way. So I wouldn't demonize the entire industry. That is what I'd say. I see all sides of it. I used to work in the industry. I see good and bad practices.
Thank you very much indeed, Nigel. Would your colleague like to chip in just to say hi? Please take a moment to introduce yourself. Please do. Thank you very much.
Victoria, what we
Yes, hi, I'm Victoria. I'm a trainee solicitor in Nigel's team, in the corporate commercial team. And yeah, I get to work with Nigel, work that he's just.
Fantastic. But we're always on the lookout for, collaboratively minded law firms that have a consumer interest predisposition. So we'll follow up, guys, and we'll talk further, I'm sure. We're going to go to Ian Duffield next, and we'll invite Ian to share any sort of final comments he'd like to make before we go to any sort of other Q&A bits as well that Ian and others may want to chip into as well. So Ian, please do chip in with your thought. Thank you, Ian.
Yeah, if we've got a couple of minutes, I've just spotted a few questions in the chat, particularly the first two of them, one from Angus and one from John Hayworth. Angus's question was if there's any guidance on how stringent the court should be when deciding whether the defect existed at the time of sale. And of course, the problem, it could become apparent after more than 30 days. And unfortunately, there isn't really. That's a matter for the courts to decide. And that would be an evidentiary matter. So things you might be able to do is an engineer's report would be the classic case with something like a vehicle or whatever, and to try and get evidence gathered in respect of the nature of the damage or the nature of the defect. And that really probably is about the only thing you can do, because it is a matter of evidence that will be considered by the courts. And the second one from John Hayworth, any chance of a word on offer to treat, offer and acceptance? Yeah, offer to treat is basically an advert. It's something that's sent out to the world at large to say, here are some goods, please come and buy. And an offer would then happen when you came along and said, yes, I want to buy those goods for this amount of money. So to put that in a little bit more detail, if a car is on a showroom and has a sticker on it that's saying £200, that's an offer to treat. Okay. If you then come along and say, yes, okay, I want that car, but at £200, I want a tank of fuel put in it, and I want a new set of tyres. Okay. That then becomes an offer. If the trader then says, okay, I'll give you a full tank of fuel, but I'm not putting you 4 new tyres on it, that becomes a counter offer. And that means that the original offer of the £200 on the one screen and the counter offer that you make of saying tank and tyres is now void. Okay, it's overwritten. So it's the last offer that is made that is important. Now, when this becomes a documentary evidence, and where this may be an exchange of terms and conditions, it becomes known as the battle of the forms. And the typical scenario there is where one party makes an offer and says, and oh, by the way, it's under my terms and conditions. And the other party then writes back saying, no, I'm quite happy for you to buy offers. No, but it's under our terms and conditions. And then you get a game of ping pong going on. Okay. And the last shot wins the battle, because it is possible to have an acceptance by action. So if you receive a set of terms and conditions from a company as a counter offer, and you then go and supply the goods without going back and challenging, that last shot has won the battle. But one thing to bear in mind, and I mention this because this has come up in the past, silence cannot automatically be assumed to be acceptance. It can take the form of acceptance by action. But if an offer is made and there is no explicit acceptance, then the contract does not come into formation. And the generally accepted case law on this is where an uncle had a horse for sale, and his nephew. He knew his nephew was interested, and he said he would sell him the horse, and he didn't need to reply. He would take it as read, and that was fine. And then later, subsequent to that, the horse got sold at auction. The nephew tried to take action against the auctioneer for saying, "You've sold what was my horse. My uncle had sold it to me." And the court decided no, title to the horse had never passed because he never explicitly accepted. And it does not matter one jot that the uncle said, "It is not necessary to come back to me." So acceptance has to be a definite acceptance or an act of some part that is communicated to the other party, not just, "Oh, it's all right, go on, it's mine, we'll take it as read." So that's just a word on those two legal points.
Thank you so much, Ian. Lou Baxter Scott has just jumped off, but she's put a link to her website, www.consumerfriend.org.uk. Sorry, I missed you jumping off there. I would have said thank you prior to leaving if I'd known that. I was distracted with something else just now. Thanks, Ian. We've got time for any sort of final comments or questions before we wrap up. So please raise your hand, preferably digitally, otherwise literally. Barry, we're going to go straight to Barry. Barry, keep it short and sweet because we want to wrap up in about 5 minutes or so. Barry, thank you.
Yes, certainly will. It's about what the guarantee, and is the guarantee subject to any limitation of time to be able to take it? The example is a £3,000 wardrobe that was bought subject to a 10-year guarantee, and the company's relocated to Northern Ireland. And so we're having problems getting enforcement there of them just to repair the wardrobe. So what's the guarantee?
Ian, do you want to pick that one up? I haven't got a clue.
Yeah, sorry about that. I was on mute. Yeah, if that's by the manufacturer or by the trader, it to a degree it's irrelevant. But that is a guarantee that is in addition to your consumer rights. Your consumer rights generally would have ended at the extreme after 6 years under the Limitations Act. But if they have specifically said this wardrobe has a 10-year warranty, then that is enforceable against them and you can take legal action against them. How you do that, that's a difficult issue if now there's a jurisdictional issue and they move to Northern Ireland. But the point to bear in mind is that I'm assuming that you bought the wardrobe in the UK.
Yes.
Right, then that's your point. The contract was made. Okay, it was made at that point. So they may have relocated, but you can issue proceedings against them in the UK, and it would be a matter for them how they defend it. Of course, the situation may then be that they don't defend it, and you get judgment by default. In which case, you can contact the sheriff's office. I don't know what the similar would be in Northern Ireland. I'm guessing they do have a sheriff's office, which is basically the bailiff. The reason I say the sheriff's office is they have more powers and they're better at it because the bailiff is just an employee of the court and they tend to walk away a bit too easily. The sheriffs are paid on a results basis. So if you got a default judgment in the UK, it could be enforceable. Whether that would be the wardrobe is enough money to warrant paying a sheriff to go over to Northern Ireland, that's a matter for yourself. But it may be that you could find a sheriff's office in Northern Ireland. I don't know anything, but I don't know much about the jurisdiction in Northern Ireland, and then they could try and enforce it for you.
Thank you.
But yes, you will face a jurisdiction problem.
Can I just add one point to that?
Yeah, please do.
When you say, Barry, when you said they've relocated to Northern Ireland, is it the same company or is it the same people in a different company? Because if it's a different company, you may find that much more difficult. That's very hard to enforce.
Otherwise known as a bump and run.
Yeah, no, it's the same company, and in actual fact, they still sell in the UK, but they just don't operate in Kent. So, and Northern Ireland is part of the UK, isn't it?
It is. It is part of the UK, but it's a different jurisdiction. So actually, you have to, if they are, the company itself would not have moved jurisdiction. They may have moved themselves, but the company should be the original company. I mean, the way to find out, just look on Companies House and look up the company, look at the names of the individuals behind the company, look at the company number. because companies can change their names, but they don't change company. But the number that is permanent. So every company is issued a number when it's formed, and if it's the same company who delivered it to you, then it's still the same company.
Thank you very
much. The difficulty is the small claims court is for money and not necessarily repair. It seems more difficult if it's repair that you're actually wanting, or part of the guarantee.
Yeah, but what you could do, of course, is have the wardrobe repaired by a wardrobe repairer, and then your claim would be for damages in a financial capacity.
You just send them the bill.
Interesting stuff. We're going to move on to see if there are any other final comments, questions before we go back to Ian, and thank Ian, and wrap the session up. Please raise a hand if you want to chip in, folks. It looks like we're all good. I'll just quickly look. Oh, Carolyn wants to chip in. Carolyn, please do. Thank you, Carolyn.
Hi, I put a question in the chat. It's how can we contact trading standards? Because to my knowledge, you can't. I've tried and failed, and ChatGPT says you can't.
Okay. Send an email to Alexandra, who runs our events, and ask her for me to provide a means by which you can contact trading standards. I say this because Lou Baxter Scott works for them. I'm sure she'd be keen to hear that people are having problems contacting trading standards. So send Alexandra an email and we'll try to do something to help you, okay?
Could just add one last thing, Andy. I'm not a lawyer. I do not give advice. So anything I've told you, you can choose to ignore it if you wish on the grounds that I'm not a lawyer. But there you go. And this is not done in the course of a business. So if you think of coming after me, bugger off.
That's quite ironically funny, that really is. For all kinds of reasons, on all kinds of levels. Can we, folks, please show our appreciation to Lou, who's no longer here, Ian, who still is, and the other folk who've chipped in that as well. Thank you very much indeed. Thank you. We'll wrap it up then. Thank you very much indeed, everybody. Great job, Ian. Absolutely superb work. Thank you very much, everybody. Cheers. Bye-bye. Bye-bye.